Canada has begun moving very quickly under its new immigration law, and the impact on asylum seekers is already being felt. Bill C-12, known as the Strengthening Canada's Immigration System and Borders Act, received royal assent on March 26, 2026. Within days, affected claimants started receiving procedural fairness letters from Immigration, Refugees, and Citizenship Canada. These letters tell applicants that their refugee claims may now be ineligible for referral to the Immigration and Refugee Board under the new rules. This is one of the fastest examples of early enforcement many immigration observers have seen after a law takes effect. The main concern is not just that the law has changed, but that the government appears to be applying the new rules almost immediately. For many asylum seekers, this means their case may no longer reach a full refugee hearing before an independent tribunal. The biggest change comes from the new one-year rule. Under this rule, a person who first entered Canada after June 24, 2020, and then filed an asylum claim more than 1 year later may now be found ineligible for referral to the Immigration and Refugee Board. Another major change is the 14-day rule. This affects people who entered Canada between official ports of entry along the Canada and United States land border, and then waited more than 14 days before making an asylum claim. If someone is affected by either of these rules, they may lose access to the standard refugee hearing process. Instead, their options become more limited and far more urgent. The article says many of the people most likely to be affected include international students, temporary foreign workers, and visitors who remained in Canada and later tried to seek protection. A major focus of the article is the procedural fairness letter itself. This letter is not the final refusal, but it is a serious warning that the person's claim may be ruled ineligible. It gives the claimant a short deadline to respond and provide evidence. That evidence may include proof of the actual date of first entry into Canada, travel records, passport stamps, or any documents showing that the government may have the wrong dates on file. If the person does not respond, or if the response does not resolve the issue, the claim can then be refused or ruled ineligible. Understand the main legal pathways that may still remain open. One option is to respond to the procedural fairness letter as quickly and completely as possible. Another is a pre-removal risk assessment, which can still provide protection in some cases. A person may also explore a humanitarian and compassionate application, judicial review at the federal court, a request to maintain valid temporary status through another immigration stream, or, in some situations, a request to defer removal. The overall message of the article is that Canada's new asylum rules are already having real consequences. For affected claimants, timing now matters more than ever. The law has changed, enforcement has started, and anyone receiving one of these letters needs to act immediately and understand that the window to protect their case may be very small.